What's going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chipkey, I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I'm good. I hope you guys are having a great night so far. Happy Friday. We made it to the end of the week. All right, we got a special night tonight. We've got a special guest. Her name is KTZED. She is joining me. Let's bring her up. What's up, KTZED? How are you?
I'm good. How are you doing?
I am doing amazing. Thank you so much for joining me tonight.
I'm glad you invited me. I'm very stoked because I watch your live streams all the time, and I always have so much to say, and it's a lot to type. So I'm glad that I'm here and I can just say it.
Well, perfect. We have a great night planned. So we're going to do part 1 on my channel and part 2 on your channel.
Yep.
So I've already got it set up. We're going to be rating your channel right after mine. You start at 9. We're going to do our best to end right at 9. If that means I'm just going to stop a video, I'm just going to stop a video because we're going to make this professional tonight.
Oh, okay. I'm not used to that.
I'm not either. I just play until I get tired and I just stop. So we're going to try our best. Anyways,
Awesome.
KTZED, talk a little bit about your channel. So for everyone that doesn't know, sorry, I just asked you a
go
question
ahead.
and I just started talking. I'm just going to say for everyone that doesn't know, Katie, you don't do a lot of court. You do more criminal videos, a lot of body cam footage type of stuff.
Yep.
So not necessarily the same thing, but kind of perpendicular to my channel.
We're in the same ballpark, really.
We're in the same ballpark, yes.
I like to catch the stuff as the crimes are happening, and then you have the follow. We should be doing this in the reverse. Next time we'll play the body cams and stuff of whatever crimes, and then we'll watch the court stuff on your channel, like one after the other.
That is perfect.
That'd be fun.
We should actually. That would have been a better setup.
That takes planning and professionalism. Whatever. We'll do it next time. I do cover a lot of different stuff that when it comes to, I don't like to say I'm a true crime channel. I'm just a crime channel because I love covering the body cams. Kafar, who some of your chat might know, and I started doing a show once a week called Booze and Body Cams, where we just watch the ridiculousness of some of these criminals. We each try to find a body cam video that the other hasn't seen yet, and so we each bring one to the table and we surprise each other, and we sip on a beer or whatever we happen to have while we do it. But my main thing that I like to do, but it's a lot of work, a lot of research, so they don't come out that often. It's called Overruled is the name of the show, and it's like a deep dive into one case, and I take it from the start all the way to the finish. So that's when you'll see some of the court stuff on my channel. Is like I just covered Sarah Boone, and we did a whole 2 hours leading up to the trial, like just the whole background, the police interrogation, all of that. And then last week I covered her testimony in court, which was just ridiculous. Why would you testify in your own defense? You don't have to. It doesn't make sense. You end up, the prosecutor gives you the rope and you end up hanging yourself with it. So that's fun to watch,
Yeah, I mean, also, why would you play hide and seek with another adult? I mean, there's a lot of what ifs you can do with her.
Don't even get me started. My favorite, I don't know how many of you out there in the audience are familiar with the Sarah Boone case, but my favorite part of the whole trial was when the prosecutor asked Sarah Boone, with a straight face, mind you, my understanding of the rules of hide and seek is one person hides and the other person counts and then goes and finds them. Do you have some sort of house rules in your house where you both hide at the same time? Priceless.
Or take a nap halfway through. I'm just tired. I can't find you. I'm just going to go to sleep.
Yeah, exactly.
I mean, that was an epic game of hide and seek, I guess. Sorry, that was a terrible comment to make. Someone did lose their life on that. I should not have. That was a bad joke.
That's okay. We do like to, on my channel, have a little bit of levity with the horrible things we're talking about, because that's the only way to get through it sometimes. You know,
I
I have
agree.
my co-host is a dog, for goodness sake, you know. By the way, this will go for any channel that I'm visiting or my own channel. My co-host is Xena. I don't have a way to share her camera right now, but if anybody does a super chat, either when we're over at my channel or in Colin's channel right now, Xena gets a milk bone. That's my co-host. I do a lot of the heavy lifting, but most of the people are there to see her. So
Fair enough. And yes, Xena is a great co-host. She does a lot of work. She sleeps a lot, and she wakes up when you say Xena Milkbone. She's like, oh yes, this is that time.
It's her job.
Yeah, great co-host.
Yep.
I want that job. Can I have that job? All right, so we've got a couple things to play for you guys tonight. I have a prosecutor that's also a judge. This is in the state of Washington. As I just told you a few minutes ago, Katie, that I don't know the legalities behind this, but she does it every week. So I'm not going to question that it's, outside of the realm of what she can do. She does it. And
it makes sense because all judges are lawyers. So they don't negate their law license in order to become a judge. So,
that's fair.
Yep.
That's fair. But I've got a really good case while she's a prosecutor, and she puts, for lack of a better word, she puts a monster in jail.
Awesome.
And
that's
then
what we like to see.
Right. And it's a kid too. The kid's 21, and he's just once you hear it, you're gonna be like, yeah, he needs to be in jail.
Yeah.
And then we have a landlord tenant case where she's the judge. Also, I have got an update on the Haley case that we've all been following for weeks now. Katie doesn't know anything about the Haley case.
Sorry.
But that's all right. But as you guys know, I am not going to share that information until about halfway through the video, just so people can roll in, because I don't want to have to pause the video and answer the question every 5 minutes just to tell you guys the same thing that I've already said. So right after we're finished with Miss Carmi being a prosecutor, right before she's a judge, I will share the information of what happened with Haley today in court. All right.
And just so your audience knows, the reason why I wanted to come on because of the landlord tenant cases, I by trade am a landlord. That's my job. Well, I'm not, I don't own the stuff. My company owns the stuff, but I actually just had to file a writ of possession today, like this afternoon. So that's what I do for a living. And I like to see those cases, and I do, warehouses and commercial properties, but it's pretty much the same sort of thing. There's some differences in laws and eviction practices and stuff, but a lot of these cases where people are like, oh, well, you didn't fix the faucet, so I haven't paid rent in 6 months. You can't evict me. I want to scream. So I'm excited about that one.
All right, good. It's a good one. It's the landlord tenant case is a good one. So, all right, you ready to go?
Yeah, let's do it.
All right. I don't have guests a lot. I've always got to figure out what button to press. Here we go. All right, there we go. I'm getting better at it.
We
Go
have
ahead, Mr.
Jaden McIntyre present in
All right.
person for arraignment, Your Honor.
Mr. McIntyre, come on up. Let's see, I already went through with Mr. McIntyre probable cause. We talked about the nature of the charge assigned. Mr. Campbell standing in for Ms. Gaffney. So the next thing we're going to be doing is talking about conditions of release. I'm going to hear from the city attorney, Ms. Carmi. I'm also going to hear from Mr. Campbell regarding release conditions. Go ahead, Ms. Carmi.
Yes, Your Honor. We are asking for a no contact order with the alleged victim. We have that prepared. We are also asking that he post bail today. We would note, taking into account unsealed juvenile history, this will be his third sexually motivated charge since 2021. He has a pending case in Oregon per III. He has a conviction in Washington. I understand he's likely under active probation. Clearly, the two prior cases are with juvenile court. The purpose of juvenile court is rehabilitation. That has failed. And I have significant concerns about this individual being out in the public where these unknowing victims have no idea of this history. I think it's a matter of time before this would happen again. So we are asking for 15,000 bail.
Is he a registered sex offender?
He does have sex offender registry indicated in his III. I don't know what his compliance with that is, though.
So is he on release conditions currently with an Oregon court?
So the III.
All right, BSBT. I always pause for birthdays, and I'm not going to deny your daughter. Happy birthday, Addison. I hope you had a great birthday, Addison. Thank you so much for, I was going to say thank you so much for hanging out with us, because that's what I always say when I say happy birthday. But
Yeah.
Addison, I doubt you're here. But BSBT, I hope you're well, man, and I hope you spoiled the crap out of your daughter on her birthday. So
Absolutely.
yes, absolutely happy birthday, Addison.
Happy birthday, Addison. You are an awesome girl.
It says probation unknown. The Washington case, though, as I understand it, was just recently, a disposition was just recently entered in April. So my assumption is he is on active probation with juvenile court. I don't know that for sure. It has not been sealed and he's over 18. Typically, if he was done with probation, it would be sealed by now. So I believe he's on probation with juvenile.
Looking at the DCH, is that the 2021 incident that's charged in 2023, the assault 3?
Yes.
And when was that resolved?
My understanding was April of 2024, based on my docket history.
Okay, Mr. Campbell.
Your Honor, I understand the community safety concerns the city is raising. I would note that my client's present. The primary purpose of bail is to show reappearance. He hasn't failed to appear at court hearings. He's appeared here today with his parents who were present. I do know that the client is engaged in certain treatments and things associated with these underlying offenses. I guess that is what it is in the light of these allegations. The allegations are that there was a consensual interaction that may have gone over the kind of past what would be reasonable. I'm not saying that the PC statement doesn't contain enough information for an assault for sexually motivated charge to have probable cause, but the parties per the PC statement were going up to Yakult to watch the sunset in the car together. I mean, I think in this instance, bail of $15,000 is not necessary. The client is present. He can, release conditions can be imposed in this case. Even, I've never had a case in a misdemeanor court where there was a no fraternization type clause put in.
I don't know how I'd monitor that.
Yeah.
'Cause that's my thing, is he can jump on Snapchat at any minute, set something else up, and no one knows his very problematic history.
Well, and I don't disagree with that, except to say that, these other matters that are in juvenile court have some level of supervision, I believe. I don't know what it is. I don't have enough information about that to provide any meaningful information to the court. So
What sort of so he's just pled though in April. Is he doing any kind of he's done a psychosexual evaluation or
he is
anything like
he
that?
is engaged in treatment with those he has was it today or tomorrow?
Not today.
He has a meeting with his counselor today. So
And had he started that program before all this happened?
before the allegations in our incident date, I know that he has been engaged in treatment for a period of time. I can't give you the start date. I could ask the client now if you want that information.
Yeah, that would be important.
When did you start treatment? About a year ago.
Started treatment a year ago, and he's already reoffended.
I was going to say,
Yeah.
when if he started treatment a year ago, was this offense in between the time that he started? Okay, treatment's not working. Lock him up. $15,000 is too low of a bail, in my opinion.
I absolutely agree. Like I said, this guy's a monster, and
Especially when it has to do with children.
it's not they're not children. So his first offense was when he was a minor, so it most likely was another minor.
Okay.
But since then, so he's 21. The victim right now is 19. So
Still, it's a sex crime.
It is. And what I want you to focus on is what the attorney said. Like, It was consensual. They went to see the sunset together. I'm like, how does that make it consensual? And even if there was some cognitive conversation with, let's go watch the sunset and we're gonna mess around. The second she says no, it stops. And if she feels bad enough where she has to run out of the car and immediately call 911, you messed up, man. Now this is all just alleged. It's alleged, but
allegedly.
But when it's your third offense in 3 years and you're only 21,
facts
I'm
though,
sorry, man.
the very most common type of, I don't know if you say I say the words on my channel, but we'll say surprise intercourse is date surprise intercourse. Not it's really hard to censor myself, but it's not the grab some woman in an alley and hold her down. It's out on a date and somebody forces themselves on the other person. That's the most common type of that crime. So the fact that they were out together watching the sunset really has no it doesn't matter at all.
I agree. And just wait till Miss Carmen comes in. She's gonna destroy this kid.
Yeah.
But since we're paused, I'm gonna bring up the super chats.
Over here.
I try to find good times to pause for the super chats. Generally, I wait in between clips, but since we only have 2 clips tonight, we're gonna have to pause it at good times. So, Lauren the Pet Lover, thank you so much for the super chat. She does not prosecute and judge on the same cases, I presume. Like she can't prosecute Joe Schmo for no. So she's a criminal prosecutor, and then she does civil eviction dockets. What the state of Washington calls, at least what she does, are illegal detainer dockets. So they're all eviction cases. So she's not a prosecutor. She's a prosecutor for criminal actions, but then a judge. I don't even think she's technically a judge. It might be a magistrate. Maybe she's a judge pro tem. I don't know, but you'll see it in a second. But I don't know what her exact title is. I'm calling her a judge because she wears a robe, but she may not technically be a judge. Anyways, Lauren, thank you so much for the $5 super chat. And then Janie, good to see you, Janie. I hope you're having fun down in Australia. Hi, Colin and KTZED. In case you don't know, Kiwi living in Australia on a beautiful. That's awesome.
It's good to know what we have to look forward to, since she's a time traveler.
She's a time traveler.
Yeah.
She's a time traveler, and I can't wait. It's cold here right now, so I can't wait till tomorrow when it's nice.
I did give Xena and Ava their milk bones. If you guys come to the second half of the show, they have their own camera, so you'll be able to see them better.
And we just got a big and raid.
Awesome.
Big and thank you so much, my friend. I appreciate it. We just got started tonight. Just a real quick recap. We have a 21-year-old. I think they said 21. Low 20s. He might be 22, 21, 22. He is now in front of the judge on a third, I don't know, sexual misconduct type of crime. And so he's going down a really bad path. Yeah. But it
sounded like full on date R word.
Yeah.
To me.
I agree. I'm trying to use my words carefully because I don't want to because I keep calling him a monster. And
allegedly.
It's still allegedly. And
Yeah.
I don't want to, get a lawsuit next week because I keep calling him a monster. He's a monster, allegedly. All right. But Biggin, thank you so much for the rate. I appreciate it, bud. I think that's it. Oh, KTZED. For everyone that's coming over from Biggin, this is KTZED.
Hello.
She has her own channel. She is my co-host for the evening, and we are going to be rating her channel after this. So, Biggin, thank you so much for the rate. Hopefully you guys stick around and come with all of us to hang out with KTZED.
Please subscribe. I'm trying to get to 5,000 subscribers by January 1st. That's my goal. And with your help, audience members, we can do it. We can do it together.
We can absolutely do it. I have the link for her video right after this. You're going to be automatically redirected, but the link for her channel is in the description, plus the link for the video that we're going to be rating is in the description as well.
Thank
All
you.
right. Thank you. Thank you for hanging out. Okay. Let's go.
I don't know if that makes this whole situation better or worse.
Yeah, I mean, I think from the city's perspective, Your Honor, I think that bodes again towards our point that we do try in juvenile court to rehabilitate and keep this from happening and keep individuals after they turn 18 from going to regular jail. But there have been 2 times now in the past 3 years where he's had that opportunity to rehabilitate. And I take exception to any indication that this was consensual. This was a 19-year-old girl who quickly got out of a car and called 911 as fast as she could. So we stand by our request that now, 3rd time in 3 years, he is a community safety risk to other females.
So I
Bad
think-
phrasing, Judge.
Say again?
It was bad phrasing and using the word consensual. I just mean that the parties were in agreement to go up to watch the sunset. Yeah, Cole, I wasn't trying to indicate that the touching that's been alleged was consented to or anything like that. I apologize.
Oh, Miss Carmen, you called me out on bad phrasing. No, you said it was consensual. That's what you said. That was your defense. And then when you got called out by the prosecutor, you're like, oh, I sound like an asshole right now, so I'm going to roll this back.
She
work that
literally
way.
repeated verbatim what he said.
Exactly.
That's what you said. That's what you claimed.
This is, yeah, being a defense attorney for this guy is not an easy job.
No.
I'm just trying to think about a less restrictive option. Articulating this, the court has profound concerns about this case. The liability, and I know I should be entering my head, but the liability that flows to a court if you were to have another act with this court recogning him or placing him on some manner of release, in particular, if he's a year into treatment and is still engaging with unknowing young women in this way, I just don't know what else the court can do. Yeah, so Mr. McIntyre, you're going to go into custody today. I'm going to impose bail in the amount of $15,000. I think that had the likelihood of even being higher based on
Are they
the
in?
fact that
Sorry.
we're clearly not understanding the ground.
Are they in a state? I know some states they have to pay the full amount, like Wisconsin. When they say $15,000, they actually have to come up with $15,000. Is this one of those states where they only have to come up with $1,500 or something like that?
I don't know. This is the state of Washington. I don't know the exact answer to that question, but I feel
don't
like
know off the top of my head.
don't
I hope
either.
it is where they have to come up with the full 15,000, because having to come up with 5 or 10% of that is not enough, not nearly enough.
no. And again, everybody, he's on either probation or bond for the last case he did this on.
3
So now-
times he's done this.
Yeah.
This is a danger to the community for sure.
Yeah. So I don't know. I don't know how the state of Washington does their bonds. I really don't.
I'll find out by the time you pause it again.
All right.
Gravity of power interacting with other people. You're going to enter a not guilty plea today. I'm going to assign 2 future court dates. Do we want to put him on next week? Ms. Gaffney is here next week.
We could do that depending on, yeah,
I just don't want this to get away from us in
It's
terms of he's
10%.
not posting bail.
yeah.
Well, the only in my experience, this type of case is certainly going to take more than a week for Ms. Gaffney to get her feet under her to be able to resolve. So it might almost make sense to just set it out 3 weeks or
Well,
30 days.
here's my thinking, Mr. Campbell. We're on a 60-day calendar if he doesn't post bail. And I can know next week if he's still in custody.
Oh, that makes sense. And then we can set
Whereas
trial
if he's
dates.
posted bail and
That's a-
he is out,
That's a great
we
idea.
have a 90-day calendar from there.
I'm sorry, I was
I'm
just
not-
thinking of the court's calendar.
That's
for next
all yeah, gonna have to wear my Halloween costume to court next week. So, okay. Okay, so Mr. McIntyre, if
Who is number 2? Who was number 2? I have no idea who that is.
She is my co-host for she's my best friend since high school, and we do the Many Such Cases show once a month where she's not on the internet like we're on the internet, so she's never seen any of this stuff. So I like to surprise her with crazy cases and get her reaction. So once a month we get together on my channel. The name of that show, I just need to just have one show for everything, but they're different genres, but I want to keep them all on the same channel. But the one that I do with number 2, she's the co-host of Many Such Cases, and she's the one where you came into the chat that one time and she's like, "Who's Colin?" And I'm like, "What do you mean who's Colin?"
I was getting her back with the joke is what I was doing.
Yeah.
So that was the who's number 2.
The stream that I have lined up for after this stream is titled "Who's Colin?"
I don't know. I ask myself that question every day. That was a fair question. I'm not mad. I thought it was funny. But the second I saw their name, I was like, I'm gonna make fun of her. Who's number 2?
Very good.
All right. Let's finish this first case real quick. We're almost finished with the first case.
You're being taken into custody. Your next court appearance is next Thursday. It's 10 a.m. if you are out of custody. It is going to be whatever time the jail brings you over if you are in custody. Your release conditions are to violate no laws, to appear at all mandatory court dates, notify the court of any change of address or phone number. I'm going to be signing a standalone no contact order with the alleged victim in this case, Ms. Berglund. This is a legal document. You're going to receive a copy of this document today. If you have any questions about whether conduct you're going to be engaging in would violate this agreement, it's your responsibility to understand the agreement and certainly to use your attorney as an option. Reach out to Ms. Gaffney. This is what I'm thinking of doing. Would it be a violation? Because not understanding or not knowing is not an acceptable defense. You're on intensive pretrial release with Clark County pretrial release if you post bail. Don't really know if there's anything else I can do. If I could take your phones away from you and your devices, I would certainly do that, because at this point you should not be in contact with any young females. If you do post bail, what is a phone number that Ms. Gaffney can reach you at?
I have all that, Judge.
Okay.
It's 360-216-6654, and I'm going to get that to Miss Gaffney.
So, Mr. McIntyre, the deputies are going to be taking you into custody, sir. We're going to get you some court paperwork as well. And that concludes the hearing for today. See you next week.
And that should be it. Oh, I always keep the perp walk in. So you can watch it be handcuffed and walked out of the screen.
Nice. Very good.
Even though it's small.
I wish it was bigger so I could see the look on his face. Just like I
it's...
wish that the camera was pointed at Sarah Boone's face when they said the words guilty. Like you could only see kind of a side profile.
Yeah. All right. So yeah, that guy was a monster. And I'm gonna tell you right now, he was supposed to be back in court yesterday. I looked up and down multiple times to try to find his appearance yesterday. He was not there. So this could mean a bunch of different things. One, his attorney pushed it out. He bonded out. His attorney pushed it out. Because if he was in custody, he would have been seen yesterday. So I'm guessing he bonded out. His attorney pushed out the date is what I think happened. But I looked. Because what the judge just said, if you're in custody, you'll be here whenever the jail brings you over. If you're not in custody, you're at 10 a.m. His 10 a.m. docket, he was not there. He wasn't in the afternoon docket either. So
hopefully we get a follow-up on this one and we can see him get some actual prison time. And not that he would learn a lesson, because I'm pretty sure that people who do that over and over and again have something wrong with their brains, and it doesn't get fixed a lot of the times. So
yeah,
that's my opinion. Allegedly, don't come for me.
All right. So anyways, let's move on just for a brief moment. The Haley case.
Okay.
Now, Katie doesn't know anything about the Haley case, so I'm going to give her a quick summary of what happened. So if anyone has heard this, I'm sorry to be recapping. Maybe you guys have forgotten. For anyone that doesn't know, it's a great story to hear. So Haley was, she's 20, she's 21 now. I think she's 20 right now. So I think she's 20 right now.
Okay.
2 years ago, her stepfather murdered her mother and her siblings, and then tried to self-unalive himself.
Okay.
So this was her stepfather that did this. Like 2 or 3 months before that, her biological father passed away from cancer.
Wow.
So she had a really tough 2 years ago. Well, since then, like it's been terrible for her, right?
Yeah.
So she was put on these. I don't know a lot of the details behind this, but she was put on survivor benefits from the state of Michigan.
Okay.
She lost both her parents, so she was essentially Social Security survivor benefits. Now they only lasted so long. She was unclear of how long they were going to last. This is from what I've understood. She signed a lease for an apartment for a year based on the survivor benefits. She showed the complex, this is my income, like this is what I get. They approved the lease. A month later, the state of Michigan shut off her survivor benefits.
Yeah.
So she was up for eviction. Now she shows up in front of Judge Simpson. She tells her story, and essentially everyone in the court community that saw this story was just like, "Wow,
yeah,
this is terrible. Like, what are we gonna do?" Judge Simpson, what did he do? He adjourned it for a week. He's like, "Okay, figure out what you're gonna do. If you're gonna move out, what are you gonna do? Whatever. Adjourn it for a week." A week later, I was on one of my court crawls, and I just happened to be in the courtroom when Haley was up. Now, one of my other viewers, who I haven't seen his name yet. No, if you're here, you might be here, but I haven't seen you yet. No, emailed the attorney of the complex. So the people that are trying to evict her.
Yeah.
He emailed her and said, there are a lot of people that want to help. Can you please ask if we can set up a GoFundMe? And the attorney just happened to see this, said it on the record. She said it on the record. Because I do these court crawls every so often, Judge Simpson and his staff knew who I was in the court gallery.
Yeah.
They walked up to me and asked, like, can you help them with the GoFundMe? And we started a GoFundMe for her. She raised $27,000.
Wow, that's amazing.
Yes.
If you can share that link, if it's still active, just share that link with me so I can share it in my channel descriptions and stuff.
I'm gonna have to go back and find it. I don't.
Yeah.
It might still be active. I don't know. Because she was only asking for, I think, 7,500, and once it hit 27,000, I don't know. I don't know if she's still collecting money on it or not. But I'll go look on it. But she had a hearing today.
Mm-hmm.
The hearing today was pretty much to see if she was going to stay in the apartment, because she wants out of the apartment. She wants to leave, but she's on this lease that she can't afford. So she wants to move out. She was given till today to decide if she's moving out or if she's staying now that she has the GoFundMe money. And judge ordered her to put the entire year's lease of rent into escrow. So the court has the entire year's lease of money. And so today she was supposed to decide. During her last court hearing, Judge Simpson released everything up till January 1st. So everything through December, he released it to the complex.
Okay.
So he's like, you have till January 1st to make you have till January 1st in this apartment, but you have till November 1st to make the decision what you're going to do.
She's going to renew or not, or
Or if but there was some kind of so this is today's hearing. There was some kind of mistake somewhere along the lines. I have my own theories that I'm not going to share because I'm not a lawyer, so I'm not going to go ahead and try to make legal arguments. But the escrow wasn't received by the complex until yesterday. Or no, it was released from the court yesterday, so it wasn't received. So as of the hearing today, the apartment complex did not receive any money. So they've still been charging their late fees on top of this. And they haven't received the money yet. So the only thing that happened today was it was adjourned for 2 weeks because the complex didn't receive any money yet. So she's still building up late fees on this for, I don't know why. Hopefully those get waived. I don't see why they would still be there if the money's there. But there was some kind of mishap. For 2 weeks ago, the money was ordered released by Judge Simpson, and it wasn't sent until yesterday.
Hopefully, and I know as a landlord that there's some discretion that can be used with late fees, but I know that for the company that I work for, if we are going to waive late fees, we don't do that. We don't do that paperwork to get that done until what's agreed to be paid is paid. So hopefully once that money hits the account, they'll go back and waive all of those late fees, or at least a couple of months worth, a month worth, something like that, what they can do. And I think in a case like this, I would be able to convince the owners of the properties, if it was in this specific case, like, please waive all of the late fees. Normally you can do like one a year or something like that, just for an everyday person. But in this case, I would hope with all of the outpouring of support from around the country that the property owners would want to get in on that as well and help this woman out,
Yeah. Hope so.
So. And by the way, if you're ever doing something like that again or let me know, because I have so many charities that I support personally that I have listed on my channel description. And I'm a very charitable person and would love to help support somebody like that. Absolutely, 100%.
Okay. Yeah, absolutely. I'm done with GoFundMe for a while. After that, it took a lot out of me for about a month pushing that.
Yeah.
But absolutely. The next time that something like this happens and I'm pushing something, I'll absolutely contact you.
Yeah. Try Give, Send, Go next time. They're easier to work with.
Okay. Yeah.
Yeah.
I've never worked with either one of them. I don't know. All I do is click and hit the donate button. That's all. I've never. Yeah. All right. So we're coming up to a wall here because this next case I have is about 25 minutes long.
Okay.
And we only have 20 minutes till your live starts.
That's okay. We can be late.
Okay, perfect. Let's play then. So, but I wanted to make sure everyone got the update on Haley.
Yep.
And I gave you the summary, so now you had an idea what I was talking about.
We're late because I talk a lot, so it's my own fault. I get it. I'm long-winded.
It's all your fault. I never pause. I never talk.
Fault.
You're absolutely right. It's absolutely your fault. Okay, let's go.
Sally I'm assuming Sally Campos. And then Mr. Hill.
I forgot what we were watching. Yeah, this was the prosecutor in the last case that's now a judge. Well, again, not sure if he's a judge, but okay, let's go.
Is your sister logging in? Do we need to wait for that?
He's trying to, but I don't think we need to wait.
Okay. All right. So let's go ahead and go on the record with this hearing. 24-200-75408. This is a continued non-jury trial. It's been a little bit unusual in that we did start it last week and Mr. Borja testified. We did admit some exhibits from his testimony. We did continue it. Mr. Hiltz is appearing unrepresented. Wasn't quite prepared for testimony, so we did give him this time. Let me just check in with the parties. My thought is I'm just going to, while taking into account that Mr. Borja has testified and the exhibits have been admitted from his testimony, we're essentially going to start with Mr. Hiltz. It is his burden of proof. We'll take testimony, any cross-examination, that sort of thing. And then Mr. Kiernan, you will have a chance to provide any supplemental testimony we'll go ahead and do closing arguments and I'll issue a decision.
All right. And as a preliminary matter, I would just also like to move as a motion to eliminate to exclude plaintiff's exhibits 2 and 3, as those are clearly declarations that were created in anticipation of litigation.
Yeah, I was going to ask about your position on the exhibit. So
I need to exclude those. I mean, 1, I guess with proper foundation could get in. I'm not excluding. I think significant amounts of that are not relevant at all. But 2 and 3, those are clearly created in preparation of litigation. One of them I created. So in the second one, it was signed after litigation. So I just don't believe they have any evidentiary value, Your Honor.
Yeah, and I guess let me just talk about 2 and 3 for a minute, Mr. Hilt. So exhibit 2 is your reply declaration when this was at a show cause level. And I'm going to repeat myself probably more times than I like on this. I understand you are not doing this with a lawyer, but when we talked last week about, hey, the things that you filed for the show cause hearing aren't automatically admitted into trial. You have to actually seek admission of those things. That was not to mean that you take your show cause filings and file them as exhibits in a trial. That's not what I meant. What I meant is we're starting at ground zero and you have to prove your case here at this disputed facts trial. So your reply declaration from a show cause motion is not admitted. You can testify to the things that you said in that reply declaration here at trial, but I'm not admitting your reply declaration that was used in the show cause hearing. So I am going to exclude exhibit 2. I find it not admissible at trial. I guess that's not to say you can't testify to those things, and I will give you that opportunity. Also, you're seeking to admit declaration of Sally Campos in support of answer. Again, that was at our show cause level, the opposing submitted a declaration. She is here today. I don't know if she will testify. You are free to cross-examine her, but her declaration used in a show cause is not automatically admissible at this trial. Some of the facts may be, but I am excluding her declaration. I'm not admitting that as an exhibit.
Okay.
We can talk about 1 as we go through your testimony. I'll reserve on 1 depending on how testimony comes out and whether you seek to have those admitted. So, Mr. Hilt, I'm going to have you start by raising your right hand. Do you swear and affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth?
I do.
Okay. So go ahead and state your full name for the record.
My name is William Robert Hiltz.
Okay, so Mr. Hilt, this will be your time to give any testimony that you would like. And then you plan to call any other witnesses?
No.
No? Okay. All right, go ahead with your testimony.
Okay. Hallie and Sector moved in February of 2023, over a year and a half ago. They testified that they had not been previously behind on rent. That's not accurate. On October 20th, 2023, I sent Hector messages letting him know that he still owed $875 towards the rent on that month. He replied that
I would object, Your Honor. I would just say that that's hearsay for, there's no business record. There's nothing that proves that they owed rent at that time. While it can be in perhaps to prove that Mr. Hiltz thought that there was money due or there's something there. I just don't think there's anything that shows that money is actually due. So I don't think it can be used for the truth of the matter.
All right. You know what? I didn't realize my camera was still off. Yeah, this is a great question, and I'm sorry to pause it right here. I was going to let this play out as much as I could, but this is a great question, especially because we raised money on behalf of Andrea. We sent her over $600 to do whatever she wanted with as a way of saying thank you for doing what she did for Haley. She's doing amazing. I talked to her today. She's the one who gave me all the updates on court. Yeah, no, she's doing great. But we sent her the money, and she said that she's using it for the way that she worded it sounds like she's using it for a trip for her and Gavin, maybe other family members over the Christmas holiday, because they all live kind of far apart from each other in Michigan. So she was very appreciative of the money that we raised on her behalf. But that was a great question. Thank you for the super chat. And yeah, let's keep going.
Real quick before you hit play again, I would
Yeah.
like just to point out this lawyer's argument that there's no proof that he owed money at that time. There's a ledger kept in any landlord tenant type situation that they can absolutely prove whether rent was owed at that time. They can produce what day the check arrived, what day the check was written. If he wants to prove that they did not owe rent, all he has to do is show the canceled checks. What day were they deposited?
The biggest issue with this case is the person that's renting the room or the place, the guy in the bottom left.
Yep.
I don't think he's like an actual like landlord by trade, and I think he just has extra space that he's leasing. All of his proof is by way of text messages and by way of emails. I don't think he has an official ledger. That's about to come out, so we may have just spoiled it a little bit.
This is not legal advice, but anybody who is going to be a amateur landlord, you must keep meticulous records. So meticulous, because you never know who's going to say what or when. You need to have records of everything. If you go and fix a leaky faucet, you need to have records of that, not text messages. You need to have the tenant sign something that says, yes, it's fixed.
Yeah, exactly. I'm never going to be a landlord, but I would do that if I was one.
Yeah, absolutely. Well, you watch enough of these cases, you know.
Yeah, right.
Asserted, Your Honor, and there's really no evidence that suggests that.
Exhibit 1, page 1 is the evidence that I was going to point to on the text message histories.
Right, but I guess the question is the relevance of this, because your 14-day notice is from July of 2024.
Gotcha. The relevance is just to show a pattern of history that they've been late since the beginning that they moved in, and that time didn't start in February.
So in civil cases, and in criminal, we can't use prior bad acts to prove conformity with those acts on the periods in question here. So I'm going to exclude any discussion of non-payment of rent in October of 2023. It wasn't pled in the summons and complaint. And so I would ask you to focus your testimony to July of 2024 and forward. Go ahead.
Okay. Starting in July of 2024 and forward, in July of 2024, they owed me a bunch of money, I guess. And
yeah, and I apologize. I do think your 14-day notice went back to February of 2024. So I just double checked.
Yeah, I think we could include February as well. I wouldn't have any objection to that. I think that's in the scope.
Yep, I think I probably confused you. That's my fault. Go February 2024 is what you pled forward. Go ahead and date as your starting.
Okay, so starting around February 2024, I know that during the month of February, Hector had made a partial payment on February 21st and on February 28th. Those partial payments were mostly back rent from January, as during the month of January, I'm not supposed to talk about that. What I do know for sure is that on March 22nd of 2023, I showed up expecting to pick up $1,850. $1,300. What's that?
March of 2024.
2024, yeah. March 22nd, 2024.
Yep.
I showed up expecting to pick up $1,850, $1,300 for the month of March, and $550 is what he still owed from February. When he paid me $400 that day, he had a song and a story, and at that point, he was so far behind. That's when I started keeping more accurate records. But at the time, on March 22nd, 2024, he agreed with the amount that he owed. On April 1st, I let Hector know he needed to pay rent. On April 3rd, Hector let me know he was home. I told him he would be home at about 5:45. I arrived, he paid me $900. I sent him the text message. paid me $900, owes $550 for March. See Exhibit 1, page 19, which matches the numbers that I just talked about a moment ago. Again, there were no claims that disagreed with the totals. On April 20th, I showed up and he paid me $1,200. I sent him a text message stating that he paid $1,200 and still owed $650. See Exhibit 1, page 20. On May 1st, I let Hector know that I'd be over in Kelso over the weekend to stop and collect some rent. Sometime in the first week of May, I picked up $480 from Sally. I did not remember to send a text message on that time. A few weeks later, I sent Hector a text message that said, "How much did you pay me last month? I forgot to write it down. I think it was $480. See Exhibit 1, page 8. When Hector did not respond to the recorded of $480, that's just what I kept it. Yes. Of note, on the same day, June 1st, when I stopped by to pick up the $400 from Sally, I also mentioned it to Sally that I needed to talk to Hector about last month's payment because I was pretty sure it was only $480 and to have him give me a call. Neither Sally nor Hector ever got back to me. I wrote it down as $480. On Saturday, June 29th, Hector sent me the following message. Can you text me when you get home? How much we owe? See Exhibit 1, page 26. He's clearly indicating that he believes he's behind on rent. I let him know that according to my records, he owed $23.70 and the remainder in 2 days.
I would just object because there's no records in the evidence, Your Honor. But he can testify to this to the extent that he believed that there was, but I would just note that there's no evidence to suggest this.
I'll allow your testimony. You haven't yet asked to have any of the exhibit pages admitted.
Oh, I would like to admit the Exhibit 1 pages, all of them. I'm sorry.
Okay. Mr. Kiernan, your position.
I think these can. I don't think that these can be used to prove that there was a debt owed because these are not contemporary business records. They're hearsay for that. There's really nothing that shows that these are records. He's even admitted himself that he was able to send a text every single time. So these aren't like a contemporary business records. This isn't a ledger. This isn't anything. So while I don't mind it being admitted for, the conversations or that, something's wrong, I just don't think this could be admitted for the truth of the matter asserted, Your Honor.
Yeah, and what I am going to admit, let me make sure. I've already.
Real quick, text messages absolutely can be used as evidence for a date. If somebody says, "Hey, I sent you the check," or "Hey, by the way, Mr. Landlord, I'm going to be a couple of days late this month," or whatever he's saying, like, you can't admit part of the text conversation and not the other part. So how much weight this judge wants to give to that part is up to her, first of all. But text messages are a great way in casual business. You're selling something on Marketplace or something like that. Text messages or DMs or something like that is a great way to keep track of stuff like that. If you don't have QuickBooks or, whatever, Salesforce, whatever you're using to keep track of, Like in my company, we use a program called Yardi, which is specifically for landlords. But if you're not going to do that, you can use text messages to keep records for sure.
I think what the attorney is that Zena here?
That was Ava. She's the terrorist
Ava.
one. Yeah, she's the puppy.
I think what the attorney is arguing is that because it's not a complete record, and that the landlord has already admitted that it's not a complete record, that it can't be used for what he's trying to use it as.
He can use it for the part he has record of.
Okay. I don't know.
Yeah.
I'm playing devil's advocate right now because
that's fine. Yeah.
Yeah, I have no idea. I'm just talking.
Well, we'll see what the judge
thinks.
thinks.
Way more than I do.
Well, the judge probably knows more than even I do, so we'll see what she thinks about it.
I hope so. She's a prosecutor. Anyway.
Yeah.
We excluded 2023 discussions. And there are some statements of a party opponent in here. I will admit it for that. I will take into account it's, I don't know that it's I will give it the proper weight it is due. Let me say it that way.
Thank you, Your Honor.
And because these are text messages between Mr. Hiltz and Mr. Borja, I'm just going to get to the relevant periods here so I can tell you what pages. Okay. I'm going to admit starting page 15 of 32. That appears to be that February time period that has been pled. And we will go through page 32 of 32. So page 15 through 32 of proposed exhibit A will be admitted.
Gotcha.
Excuse me. Page 1 through 14 is rejected.
Your Honor,
Yes.
would you mind if we, for the tracking the record of the exhibits 1 through 14 would be 1A and 15 through 32 would be 1B?
That'll be perfect. So just for the party's reference, what's been attached is pages 1 through 14 of proposed exhibit A is now going to be called 1A. That will be rejected. What was previously submitted as pages 15 through 32 of proposed exhibit 1 is going to be relabeled 1B, and that will be admitted. Do you want a minute to do that? Okay, we're fine to go ahead. Okay, go ahead, Mr. Hiltz.
Okay. Just one moment, please.
He is soaking in confidence right now.
I think what I'm going to do is start my stream and share your stream as if I'm sharing a news story or something.
Okay.
And then I think that's the best. We've never done this before, guys. So a little inside baseball. I think.
Yeah, we decided not to do the co-stream or the multicast. We decided not to do that. So when I say we, I decided not to do that. Like, no, let's not do that, and let's just do a traditional thing. You know, because what you and I have is special. We don't need to do what you and KFAR do. Come on.
I like the idea. It's just we need to practice implementing it. Do you see what I mean? Like, this is the first time we're doing it this way. So implementation is we'll get better at it next time.
We will. All right, but that's a good idea. So you can go. I will excuse you from court, and you can go start your stream, and we will all be over there shortly.
Okay.
Hold on. I'll give you the exact
still
time.
be here. So.
Oh, you're still okay.
I'm gonna stay here.
Okay.
But I'm gonna share. We'll just keep going like nothing happened.
All right, let's go. Before we start, though, I'm gonna read this off. Thank you, David Thomas, for the super chat. I appreciate it. Colin, you not only give us court, but you help people. I appreciate that. I try. I do try. I do appreciate it. Thank you for the kind words. Thank you for the super chat. Okay, let's go.
During the months that they were paying rent and I was keeping track with the text messaging, Hector and I, he was the sole person of communication. I rarely spoke with Sally about any of this money. He and I never had a disagreement with the amount that was owed until just recently. I guess I don't know. I know that at one point, when they owed me a couple grand, I encouraged them to move out. And just keep the money. They weren't interested in doing that. Hector indicated he did not wish to move out, and he said he wanted to catch up on rent. That's when he reached out and said, "We haven't found a place yet, but I got $2,000. If you can give me a week, I'll give you the rest." Exhibit 1, page 27. Can't look what date that was on. It was on or around this time that Hector started paying through Walmart. I was very grateful to have this alternative form and was hoping he would catch up on rent. On July 31st, I sent him a text message asking if he had the $1,670 still owed from the back rent, considering the following day would be another $1,300. See Exhibit 1, page 30. Again, Hector followed up asking, give him another chance and not to file this civil action. Exhibit 1, page 30. Not once did he mention he didn't owe me back rent. Regarding the withdrawals from Hector's PayPal account, a cash withdrawal is not a payment of rent. I would assume that he had other bills to pay. It might even be true that all the money he took out of his account went to me. I can't testify to that. All I can say is that the dollar amounts that he paid me are the ones that I've listed in what has now been excluded. So I'm not sure if you have a clear list of the dates and payments, because on Exhibit 2, page 5 is what I was planning on talking about.
Well, you can testify to it.
Okay. So yeah, on February 1st, at the end of February, he owed me $550. On March 22nd, he paid me $400. On April 3rd, he paid me $900. On April 20th, he paid me $1,200. On May 5th, he paid me $480. On June 1st, he paid me $400. On July, he paid me $2,000, July 1st. And then July 31st, he paid me another $800. Since then, he's paid me the $1,300 for October's rent to recently. But other than that, I haven't received any payments from him. And if you total it all up, my numbers have been consistent, and he owes me $3,470 today.
Anything else?
I don't think so.
Mr. Kiernan, any cross-examination?
Yes. Do you have any contemporary, or did you take any contemporary records that would show that you were keeping these values owed, like a ledger or anything like that?
Just the text message. I thought that by sending a digital record from me to him, that would be enough record keeping to satisfy.
So a text, just to confirm, these text messages are the only ledger that you are keeping running?
Yeah.
Okay.
I mean,
I would just like to have your direction to page 10, where it stated, or 1 second, Your Honor.
Me real quick. You know what? I don't know what state this is physically in. It actually could be Oregon, which would answer the question that I had earlier. Miss Carmi, the judge right now, is a prosecutor in Battleground, Washington. Maybe she's a prosecutor in Washington. She's a judge in Oregon. Maybe that's how she does it. Maybe.
That could be.
Yeah, that would answer the question of how she can do that. I just thought it was criminal versus civil. She could do it, but if it's a different state, good for her.
Yeah.
Or page 24, where you stated, I forgot to write it down. How much did you pay?
Yeah.
Is this a text message that you sent?
Yep.
So did you fail to account for that day?
That one time, yeah.
Does that mean that you were not, can you say that you were keeping running totals every single time then, or?
Yes, every single time. That was the.
Okay, but this one time?
But the one time. And if you'll notice, that was the $480 that I mentioned.
And again, the only records that you were keeping were these text messages that you were sending. You have no like business ledger or anything like that?
No, I do not.
Are you the only one that ever picked up the rent?
My father picked up the rent back last year, December 2023 and prior. Since January, I've been doing it, I think, exclusively due to the fact that he's so far behind. I didn't want there to be any confusion.
Are Hector and Sally the only people living in the unit, or is there another person renting out?
There's two units there. There's an upstairs unit.
Do you collect rent at the same time?
Sometimes.
Do you have any system to separate the rent between the two, or do you just pick up cash all at once?
I pick up cash all at once and or checks, depending on the upstairs people usually pay me in checks.
Okay, but do you have a system for clearly delineating who picks up which rent? Or which rent is owed by which person?
I don't. I'm not sure what you mean by a system. By a system.
Ledger, a record, any sort of record.
Just the text messages.
So is it possible then that you could have, if one was paying the cash, you could have confused the two, or you could have accidentally done one to another one, or applied an amount incorrectly?
Anything's possible, but like I said, they usually pay with checks. Occasionally the young lady upstairs will pay with cash, but they don't even usually pay on the same day. I usually go there multiple times a month. No, I have not confused anyone's rent money with each other.
But you just testified that you can't be sure because you don't have a system.
Now I I testified that I can't be 100%.
Yeah, this is where he loses his case right here. He just said anything is possible. Is it possible that you mix up that right? Oh yeah, anything's possible. And now you're backing out of it. Just don't say that. Just don't say that. Tupac. Yeah, right? I mean, just make up. Like, no, I have two pockets. I have two units. I put one in my left pocket, one in my right pocket. I don't mix them up. Like, just say anything besides anything is possible. So this attorney's good. This attorney's
absolutely.
good. He's,
what we're going to do, since I can't get the camera on these two on your stream, when we jump over to my stream, I counted 3 came in since the last time I gave them a milk bone. So you're going to get milk bones right at the beginning of the stream when we jump over there.
All right, we have this video is 37 minutes long. There's 5 minutes left, so
okay.
I'm probably just going to pause it one more time at the very end.
Okay.
Don't count on that because I pause it a lot. All right, Tupac, very generous of you. Thank you so much for the 10 gifted membership and welcome to the 10 new members. Thank you so much, Tupac. That's very generous of you. Also, this attorney is legal services. He's a free attorney to people that qualify for his service. That's what makes him even better because he is so good.
Yeah,
I watch this docket almost every day. Yeah, and you know, his clients might be dead to right now. Like they make like it sounds like they haven't, you know, they've been inconsistent in paying. The landlord has every right to evict him, and this guy's like, "Sorry, man, you are not good at what you do, and I'm going to destroy you." And he does.
That's great that there's good legal services like that.
Yeah. He's this good against other attorneys too, not just the pro se landlords. He fights for every single client. I've shared him before. He's fun to watch. He's very what's a good word for it? He's very energetic in every single one of his cases.
Yeah.
Yeah. Okay.
He's entertaining and smart.
Exactly. All right, let's finish this up so we can go raid KTZED. We are running really late right now. Okay.
I'm sure nothing ever got mixed up. The dollars that I've admitted to are, to the best of my knowledge, the dollars they owe me.
How can you be sure if you did not keep separate records for your 2 units?
I have text messages from all 3 different parties with 3 different conversations going all the time, and they pay on time, so I don't have to keep records for them. They pay me checks on time. They owe.
So you just don't keep records for this other party?
I mean, we have not been sending text messages back and forth. They pay me rent every month. I put it in the bank.
Okay. No further questions, Your Honor. Quite frankly, I can have Miss Camposter, but I'd just ask for a directed verdict at this point.
Mr. Hiltz, do you have any other testimony or witnesses?
No.
Okay. Yeah, Mr. Kiernan, what is your motion?
I just asked for a directed verdict, Your Honor. He's provided no evidence here. He's testified on the record that he's not keeping, clear business records. My client, we have undisputed records that my clients are planning on. I just feel like they have not carried their burden of proof in this matter, Your Honor.
So, Mr. Hiltz, a request for a directed verdict is for me to determine, since you have the burden of proof, to prove more likely than not that you're entitled to possession. The defense is asking for a decision on whether you've met that burden of proof. If you haven't, they're not required to present their case because the burden doesn't shift to them.
Right.
If you have met your burden of proof, then we do start their case, and I then balance the testimony and evidence. I am granting the motion for a directed verdict. You have not met your burden of proof through any admissible evidence to show me more likely than not that the amounts in question are correct. I believe that you were in front of Judge Evans at the show cause level, and the same issue came up, that there is no ledger, there's no bank records, there's no deposits, there's no evidence, credible evidence to show what was due, when it was due, and what was actually paid. I do, in finding that you have not met your burden of proof, take into account the page 24 of exhibit, that's what's been admitted as exhibit 1B, where you indicate that you did forget to write down a payment in the prior month. You asked, I think it was $480, but there is no response confirming that. So I cannot find, without basically better record keeping, that you've met your burden of proof. So I am issuing the directed verdict. This case will be dismissed.
Your Honor, I would ask for my fees to be paid for just for the trial, as we did everything we could to prevent this trial from happening, going back to Judge Evans' verdict. Not the entire matter, but I do think that this trial was largely unnecessary, Your Honor.
Yeah, I will grant reasonable attorney fees. You can note that on, if you want to.
I will note that for maybe 2 weeks from now.
Yeah, we can submit that. I can put you guys on, or you can just note it.
Let's just note it because we might negotiate the fees away, quite frankly, Your Honor.
Okay, so I'll put you all on for presentation of the orders. That will include also the dismissal order, unless it's already been agreed and signed, to November 8, 2024 at 9 a.m.
Thank you, Your Honor.
Okay. All right. Anything else from the parties?
And I would ask for an order of limited dissemination for both my clients, as there's no basis for this.
I will grant, and also I will sign an order of limited dissemination.
All right. Thank you, Your Honor. And Ms. Campos, I'm going to give you a call right now, okay?
Anything else from any party?
Your Honor.
Oh,
can
yes.
I ask, at the last trial, did Mr. Cameron get an exhibit admitted?
Yeah.
We did at the end.
Yeah, it was the
So if he could indicate whether or not he wants.
All right, we're done. We're done. They're going to talk about destroying the evidence that, or not the evidence, whatever they submitted. They're asking if they're going to send it back or destroy it. Real quick before we raid, Peeps, that is awesome. So happy to hear that. That is awesome. I'm glad to know you in person, Peeps. I really am, and that is very good news to hear. I'm happy for that. Thank you for the super chat. All right, that's it, guys. We're gonna finish this up. There's about, hold on, KTZED has her finger up. I don't know if she's talking to us or her channel. I don't know. We're going to finish this up, and then we're gonna read.
I didn't account for the delay, so I'm sharing your stream from YouTube onto my channel, and it's a crazy 3-second delay, so I'm hearing everything twice.
Okay.
So I'm gonna jump
fine.
over there and talk to them for a minute. How much longer is on this one?
There's only about 30 seconds with the
30.
outro. We'll be over there in probably 1 to 2 minutes.
And you have the link?
It's already set up. Yep.
Perfect.
For everyone that doesn't have it or doesn't want to wait for the automatic redirect, it is in the description. So you click on that. There's a link to KTZED's channel plus the link to the video that she's about to play. But you will be automatically redirected if you don't click out of this window.
And please subscribe while you're over there. We're trying to get to 5K.
5K. She's about 500 away to 5K. So
we'll see y'all in 2 minutes.
Sounds good. See you soon.
Okay.
All right. Everybody, thank you so much for watching. Biggin, thank you again for the raid. That was awesome of you. Thank you guys for the super chats and the gifted memberships. Let's go support KTZED and let's watch some police body cam footage. So let's go. You guys are awesome. I will see you Sunday. Tomorrow night's my night off, so I will see you on Sunday. All right. Until next time. Well, no, I'm going to say until next time. Bye on my channel, but I'm going to be hopping over there in 2 seconds. So I'll see you guys soon.
Is that return to destroyed would be great. We can
Destroyed, please.
Destroy. Okay. They will both indicate agreement to destroy exhibits. Okay. All right. Thank you all. That concludes our trial today. I will go ahead and log off of Zoom.